Let's bring in Jonathan Turley, Fox News contributor and constitutional law attorney. So we do know what was unsealed today, and that was the motion to seal the affidavit and the order of the motion, to seal it. So that's not going to tell us a whole lot. Though Deanna Shulman did say, while she didn't get any clues from the DOJ as to what's actually in the affidavit, it presents a roadmap for the investigation. It includes information about confidential informants and witnesses. This was a rather Solomonic decision by Judge Reinhart, really seeking a middle ground here.
Well, it was, as we were discussing before the hearing, I said that I have no doubt that portions of this affidavit could be released in redacted form, and the court seems to have reached the same conclusion. If you're familiar with these affidavits, there are sections that would not inherently damage an investigation because it's information known already to the other side. For example, communications that were made leading up to the raid, some of that might be able to be disclosed. I was sort of noted a couple of points of what Shulman said as to what occurred in that courtroom, and it may be that this was slightly inartful, or it may be something that we have to be concerned with. First, she did refer to multiple confidential informants, not just one. She used the plural at one point. But I'm more interested in the fact that the process she described was that if the judge disagrees with the redaction proposal of the Department of Justice, he will issue the order saying, I disagree, and then allow them to appeal. The suggestion is that nothing would then be released. That would mean that even a small disagreement with the government over one section could keep all of the sections from being disclosed. The alternative is to say, well, I agree with you on 1 through 9. I'm going to go ahead and release that material, but I'm telling you I disagree with you on number 10, and you can go ahead and appeal that. So there's a very different process in terms of what we would get in the short term, because the way that Shulman described it, once again, I'm not criticizing her, she was in front of cameras, I'm not too sure if that's how the order was written, but if it is going to be written that way, then you could have the entirety of the affidavit held up by the appeal over a portion of the disagreement. So that's something that we have to sort of look at. This is not like the normal fight. You know, I'm cleared counsel in national security cases, including one now. So when we have fights over the release of information, I'm allowed to see the classified information in a SCIF, and I can then correspond with the judge and the prosecutors as to why I think the Department of Justice is being overbearing or overextending its claims. So it's not an ex parte communication. It's not just between counsel and the court. The reason that's important is because I likely have a lot more information than the court does on what is classified as the cleared attorney, but also what is legally permissible to be released. This is going to be different because he's not going to have the input of an adversarial lawyer. He's going to have what is very likely to be a very aggressive redaction proposal from the Department of Justice, and he's going to have to eyeball it and make a decision. I just don't buy that. Now, can he do that without adversarial input? Yeah, he can. Because a lot of these affidavits, as I said, have sections that I would think could be released in a redacted form. But that is one difference in this process than what we normally deal with in sensitive criminal cases.
All right. Well, we will find out next Thursday what the government is proposing. Jonathan Turley for us. Jonathan, thank you. And we will be right back. Stay with us.
I'm Steve Doocy.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.